To those in the industry, an accident, any accident, is a regrettable, tragic event. But there are many out there that see it as an opportunity. They live by the mantra, hit a truck, get a check. They look at your units as being 18-wheel ATM machines. The verdicts are reported in the news and touted on their web pages. What can we do about them? And how can we go forward? Well, that's what we're going to look at first off, and I've got some help today with some great people who have researched and published on this topic within the last year, leading off with Rebecca Brewster, President and Chief Operating Officer of ATRI, the American Trucking Research Institute. They recently did a study looking at nuclear verdicts from both a quantitative perspective. What do the numbers tell us? They called tons of data in order to formulate the bases for many of these verdicts, and then coupled that with a qualitative analysis gleaned from interviews with plaintiff attorneys and defense attorneys, as well as those in the insurance industry and the trucking industry itself. The next person I have is Dr. Bill Kanaski, a behavioral psychologist. Bill recently published an article on nuclear verdicts in DRI, and he'll draw on his specialty to help us understand these. Finally, attorney Bob Tyson from Southern California. Bob recently researched and wrote a book appropriately titled Nuclear Verdicts. Well, I started off the interviews with all three of them in terms of what is a nuclear verdict? How do you define it from the perspective of your specialty? Here's what they told us.
But for our qualitative analysis, we conducted fairly in-depth interviews with attorneys on both sides, both trucking defense attorneys as well as plaintiff attorneys. We talked to a lot of subject matter experts in the insurance industry as well as motor carrier safety experts. And we posed this question: what do you consider a nuclear verdict? And the consensus was, based on those interviews, that you really start to look at what we would call a nuclear verdict when you get above $10 million.
So I think it's really dependent upon the industry. But I think in general, we could all agree that the nuclear verdict, or what we would call this 30 years ago or 25 years ago, the runaway jury, these are just verdicts that are very outside of the original economic assessment of the case.
Really, the way I look at it is I used to look at it, where it kind of shocks the conscience, but the verdicts are so big now, nothing's that shocking to jurors or to Americans. So it's more where the non-economic damages are so disproportionate to the economic damages. It's when you have an award that's $1 million in economic and $9 million in non-economic. And in my mind, that's a nuclear verdict.
Here are the definitions from the respective specialties of each. Let's start off by taking a look at the ATRI report. The ATRI study includes both a quantitative and qualitative analysis. In the quantitative analysis, it begins by noting the significant increase in verdicts and the amounts over the last number of years. The average number of verdicts greater than $1 million by year. The number of cases with verdicts in excess of $1 million. And for our purposes today, cases with verdicts over $10 million. And the rapid increase over the last 12 years. Now, before you discount these as being reflective of either the inflation or increases in medical costs as a driver, you'll note that neither of those cost levels match either the amount or the increase of verdicts over that period of time. The quantitative analysis by ATRI also looked at what can be the driving forces, what are significant factors within these cases. They document the difference in average verdicts based upon the nature of the accident itself. They also looked at types of injuries. For example, the difference in a verdict involving a traumatic brain injury case as opposed to those with no claim of traumatic brain injury. And among the significant findings was the average verdict size with a child involved in the case. The study not only looked at the individual effects with regard to the nature of the injury or the type of the accident, but it also considered and provides the data for the combination the amplification of such a situation where you have multiple of these significant factors combined together. Rebecca tells us about that.
It does indeed. I mean, we these slides touch on individual factors, but you could start to line them up, and the report does that as well, where you can say, it was a crash where the truck rolled, there were children involved, someone sustained a traumatic brain injury. You're likely going to experience one of these nuclear verdicts.
He actually studied from the quantitative perspective with regard to the demographics, nature of the injury, who's involved, and what type of crash it is. But another key factor in terms of determining a nuclear verdict, as those of us who travel around the country for trucking defense know, a lot of times it is where the accident occurred, or perhaps more importantly, where suit is brought. Rebecca tells us what ATRI found in terms of one of the other key factors giving rise to a nuclear verdict.
Well, like in real estate, location, location, location.
There you go.
Where you try that case makes a difference. And so this represents the percentage of verdicts that went to the plaintiff in the states where we had data in our litigation database. And so the darker the state, the higher the percentage of those verdicts went in favor of the plaintiff.
When we're talking judicial geography, particularly in terms of nuclear verdicts, what comes to mind but judicial hellholes? Well, I reached out to the folks who make that determination and list every year, the American Tort Reform Association, and I was assisted by Lauren Sheets-Gerald, Director and Counsel for Civil Justice. She gives us some insight as to what they look for and how they determine it. I'm sure we all have our own list. This is how the folks that do it decide.
These are places where judges are allowing either novel theories of liability to be pursued by the plaintiff's attorneys, or they're allowing liability expansion at rapid rates. We see a high rate of nuclear verdicts or excessive verdicts, in the hundreds of millions of dollars. And the plaintiff's bar is very familiar with these hellholes. They often have low barriers of entry. They have low standards for expert evidence. They allow plaintiffs from all over the country to file. So often venue reform is lacking. Personal jurisdiction decisions are very, again, low barriers. So the plaintiffs' lawyers flock to these jurisdictions to file their lawsuits. They're known for their high awards and their plaintiff-friendly rulings.
Well, that's what they look for. And for 2019, 2020, what did they find? What's the list? Here you go.
So this is the 2019-2020 list. We have several perennial hellholes on there. This was released last December and is what we have been focusing on for this year. Our new list will be released on December 8th. And we did have a few newcomers last year, and including a new #1 judicial hellhole, which is, as you can see, the Philadelphia Court of Common Pleas.
First the Super Bowl, now the judicial hellholes, new meaning to the phrase Philly special. Well, those of us who do this know that it's not just the numbers, the quantitative, or the geography, important factors all, but there's more to it, a more visceral level. Behavioral psychologist Bill Kanaski looks at it from his particular field and gives us his input as what he sees as the #1 factor that can lead to detonate a jury into a nuclear verdict.
And #1 on that list, and it's a reason for #1, because it's by far the #1 predictor of not just verdicts but damages, is the quality of the witness testimony from the defendant.
And the problem witness, their testimony can have ramifications far beyond just their own questioning an area of testimony.
Problem witnesses for defendants really seal the deal very quickly on liability. And then we start talking about nuclear verdicts, the more dislikable these people are, and the lack of trust, the lack of believability, some sense of sliminess even perhaps. This is what gets juries really out of control with those dollar figures. And so that's really the top factor pushing this, which, by the way, highly preventable and highly controllable.
Preventable, controllable. All right. So what do we do? Well, early on, we start by identifying who is the key witness, the key person in that case. Somebody at your company, the driver, combination of those. And we get a read on them early, talk to them, sit down, spend some time with them. And if that person needs help, needs assistance, we work with them, both on the verbal and nonverbal communication so that they can present their testimony in the way that is best for them, themselves, and for their company. And we do it early on, before their deposition, because once their deposition is done, it's perpetuated, it's locked in. If we change it between now and then, it looks artificial. And that would just add to the blowback from the jury on it. So why can one person be so crucial? How does that make them so crucial? Well, Bob Tyson lets us know and gives us information in terms of what is the one key factor from his perspective that is present in every nuclear verdict that he has studied.
There is one main driver, and everyone kind of needs to understand this, that nuclear verdicts in the last 10 to 15 years almost never happen unless a jury is angry. That's a big change. Nuclear verdicts in the last 10 to 15 years, the focus has been on getting the jury angry. So anger is the number one driver, the number one factor of any runaway jury verdict.
And where do they seek to generate that anger? By targeting our client, our witness, our individuals, giving more urgency and making it more crucial that they be prepared and we be ready for that prior to the deposition and ultimately prior to trial.
And it has to be done before deposition because remember, they've changed the way they try lawsuits. They're not focused on their client, they're focused on our clients. So we need to address that. You, the client, need to be challenging your defense lawyers like, hey, what kind of witness impression do you think my guy is going to make?
Witnesses. They can be a potential detonator for a nuclear verdict, but in today's world, there are others. Visual evidence, video. If you're like me, I've had videos captured from the surveillance cameras of a rural warehouse to a passing Uber driver in downtown Manhattan. Many times they're helpful. But what about those times that they're not? What impact will that have on a jury? Here's Bill Kanaski's thoughts with regard to the video evidence.
Because when jurors see that stuff, particularly in the form, especially now in 2020, electronic communication, pictures, videos. This is stuff the jury cannot unsee. Mm-hmm. And so I think it's very important that these cases get properly assessed and worked up initially to really position them for settlement. Because if you get into a courtroom, the jury will never forgive you for some of this stuff.
Any question that video is impactful? Well, as Bill discusses, it's not just in the litigation context, it's in today's world in terms of the impact of the visual, of the video, and its effect on people in general, and jurors in particular.
On the news, and the only thing I see is video, trying to get voters upset. Which, by the way, who are the voters? Oh, they're your jurors. They're the same damn people. And so anything that has visual stimuli that is controversial, negative, shocking, these are the things. You talk about nuclear verdict. I don't even know what the word above nuclear is. Thermonuclear, I don't know. But I think that's where you see some kind of even crazier than we've seen is where you have these cases that have video/audio of very bad things happening, which really drives a lot of emotion. That's what you see. And politics is driving this right now, but so is the plaintiffs' bar, and it works on both ends.
We've looked at a lot of factors that can be a detonator for a nuclear verdict. So what do we do? Well, before and early on in that case, let's do an analysis. Let's look at it. Are those potential factors there, the quantitative, the qualitative, the witness, the video? Are they there, and is that something we need to get ahead of? Deal with sooner rather than later. Rebecca gives her thoughts in terms of the value and the use of the ATRI study in that regard.
first and foremost, do that risk analysis before you go into court. Take that quantitative data that we've accumulated in this database and analyzed in the database, and really understand, was there something operationally, safety practice, driver hiring, that we could have done differently to avoid this crash? Know what you're going into before you get there.
The ATRI study gives us some lead in terms of the quantitative factors that may play a part in indicating that a nuclear verdict is a potential in a given case. Many times, however, the assessment goes beyond that and requires a deeper look at what the factors and the potential detonators are in that particular case.
So another reason why nuclear verdicts happen is really a misassessment, bad assessment choices early, and a lot of hunches about what a case is actually worth, rather than putting the time, energy, and yes, money into jury science to figure out what the case is actually worth.
An early assessment lets you know what you're dealing with, what you're presented with, what the potential is. But additionally, that early assessment can be used in the mediation of the case, presenting it as a foundation and anchor for what you contend the value is and your negotiations off of that anchor. Volkanovski indicates that a number of his clients have turned to and successfully used jury research before the mediation, rather than waiting for several weeks before trial. Here's what Bill has to say.
Well, we have many clients that will enter a mediation with our report, going to the mediator saying, hey, we hired people with PhDs in behavioral science. Here's the sample that they recruited. Here's what we showed them. Here are the results, meaning this is roughly a $5 to $8 million case. It's not the $55 million case that they're demanding, and we have scientific proof. And that has worked very, very often.
All right, you've assessed the case. You've tried mediation. That doesn't work. You're headed for trial. So what is the key to avoid that nuclear verdict in trial? Well, a common thread has run through all three fields whose expertise we drew upon in this conference, and that is the need for us to humanize our side of the case, be it the driver, the defendant, or the corporation itself. They all note that that is a practice of the plaintiff, and where too often we are failing. Rebecca talks initially about what the findings of the qualitative analysis they had in talking to both plaintiff and defense attorneys was in this regard.
Well, again, and this goes to our point earlier about humanizing, that's a noticeable difference. The defense side recognized in themselves, but the plaintiffs also pointed this out, that often the defense will follow on logical arguments. This is how mechanically a truck operates. This is, brake stopping distance, whatever the case may be. Whereas on the plaintiff side, they often will appeal to emotion, which appeals to all of us. And so, for instance, if there's a crash that involves children, they'll bring in a sibling and put them on the stand and talk about, my brother's in a wheelchair now. So it really appeals to the jury, to their emotional side. And we need to recognize and do a better job of doing that on the defense side. So things like saying, this truck driver has been a little league coach for 30 years in your community. Everybody knows him. That type of humanizing of the defense side is needed.
Bob Tyson, from his perspective, applies it not just to the individuals, but also to the entities involved in it, be a corporation or otherwise. Here's what Bob has to say.
So I don't care how big it is. I don't care if it's a big governmental entity. You need to tell a human story. There has to be a face or multiple faces to the client, and waiting for trial to prepare them is way too late.
In preparation of his book, Bob Tyson has read numerous closing arguments of nuclear verdicts. And throughout, he has found a consistency that he shares with us today.
And there's a pattern. They all fit a pattern. And that's where the book comes in response to. And one of the patterns is when you're done reading the closing arguments, and the trial went for a month, 2 months, however long it went. When you're done reading the closing, you have a really good feeling for who that plaintiff is. Like, you know that feeling. They do a recap of where they were born and what their family life was like. And this could be like a 50-year-old woman, and you know that she played sports when she was younger, and she was a strong girl and became a mature go-getter woman. And then on the defense, almost bar none, when you're done reading the closing argument in a nuclear verdict, you know nothing about the defendant. Nothing, zero.
And having focused my practice on trucking defense over the last 15 years, I've come to have the benefit, the honor of knowing a lot of drivers. Each one of them has their own story, their background, who they are, and what a great person they are. This is what we need to bring out, to show to the jury that this isn't just some perception they've gotten from some skewed impression in the media or in movies or somewhere else. It's a human being like them, with a family, active in the community, driving safely so they can get home to that family every night, constantly keeping in mind that those on the road with them are somebody else's family. That's the story we need to tell, to bring home the human aspects of that driver so the jury knows that this isn't an impersonal, this isn't somebody driven by money or somebody driven by malevolence. It's somebody like them, a community member. As a whole, as an industry, with the pandemic and the lifeblood of America being Americans truckers, we're looking at this having increased in stature in view of the jury, of what the trucking industry does and how it operates. Rebecca shares some of her thoughts in that regard.
If there's a silver lining to come out of the pandemic, I think this is one of those. Both sides said that when a verdict goes in favor of the defense, it is often because the jury understands how critical the trucking industry is, that particular trucking fleet is to their community, and how that truck driver is a member of their community, really humanizing the truck driver and what they do. And certainly, as we've seen in COVID-19, with truck drivers being classified as essential workers and everyone really starting to connect the dots that, you know, if my store shelves are running bare, I need stuff, it's going to come on a truck. And so we need to understand and respect those truck drivers. And we've really seen that, you know, rising of the stature of professional drivers as a result of the pandemic. Those of us in the industry have always felt that way, but to see the general public understand that, I think, is going to make that third bullet point a little easier going into court now, because if the jury understands how trucking impacts their lives, they're less likely to say, oh, that's just big corporate business, let's stick it to them.
Beyond the driver in the industry, there's often another story to tell, and that's of the company. You know, through my involvement with the trucking associations of various states, particularly Pennsylvania, as well as the ATA, I've come to know the people who own and operate the companies. In many cases, it's a generational association. It is one in which they are the second or third of their family to have operated the trucking company. And in doing so, they have operated that company as great community citizens, being involved in many activities, as well as being committed to safety generation after generation. Another point raised by Rebecca as she relates in her comments.
An important piece going in, if you're going to go take this to trial, you know, helping the jury understand this is a 3-generation business that's been supporting this community for years, been providing jobs for this community, good paying jobs for this community. You know, tapping into that, look what happened during the pandemic. These were the people who kept your store shelves stocked. I mean, it's just, I think there's a great opportunity for us, but helping the jury understand how valuable these men and women are who drive trucks. They're not out there to harm anyone. They want to get home at the end of the day as well.
You know, it's necessary to tell the story of our driver, our company, and to relate that of our industry. But it's also necessary to prepare at the end of the day to do what is need to be done, and that's a fight. To give everything we have to protect those great men and women who drive the trucks and operate the companies. To protect them from the ultimate verdicts, and be prepared to litigate this, push this, fight this to the fullest extent possible. Bob says it quite well in his following comments.
No, it's a fight for justice. It is a fight. Plaintiff's bar knows that, and the defense lawyer knows, well, I'm going to trial today, and there's a lot of good defense lawyers, but I think a lot of people get shocked. It's like Mike Tyson said, no relation. Everyone's got a plan until they get punched in the mouth.
Yeah.
And plaintiff's lawyers come out and they punch you in the mouth. So get ready. Figure out what's going to make the jury angry. Get ready. Diffuse it, right? Block that punch, right? Be ready for it. Diffuse it, and then punch him back. Punch him harder than he was going to punch you.
In this era of nuclear verdicts, we need to take the fight to them. We need to be prepared to respond to that accident immediately, and then do so when the accident occurs. Look, we can lament our fate and those billboard attorneys who are directed against us, but we have an advantage none of them have. We know about that accident before they do. We have the advantage of immediacy. And if we don't take advantage of it, if we're not prepared, then we have squandered our greatest of assets. After the accident, you get the letter of representation, we fire one back. We're the counsel for the trucking company and the insurer, direct communication to us. And by the way, enclosed, please find a medical release and an employment release. Send us a list of the medical providers and the employers with those returned releases. Soon after the case, ask for an independent medical examination. The response is, well, litigation hasn't started. What right do you have? None. But here's the deal. You can agree to it, or you can deny me, and I have it on record that you've refused to go for an early medical examination. And what do you think that means? And if we have an argument on liability and we've suffered damages, property damages, cargo, etc., sue them first. In many jurisdictions, you can establish or lock in jurisdictions, keep it out of those hellholes or plaintiff-friendly forums that we talked about before by starting suit first. You can then get a jump on discovery, and in some instances, you may even be able to preclude a plaintiff's action by either collateral stop or res judicata. Those nuclear verdicts and those who pursue them are not going away. The response is for us to take the fight to them. Now, Bob discusses what can be done to institutionalize on the insurer and the defense attorney basis, preparing and looking at those inflaming aspects of the case, those detonators in a nuclear verdict in the processes that we have.
So to all our clients out there, I would say if you require pre-trial reports, if that's something you require, I wouldn't change them. You have them, you want to know about the venue, you want to know about the judge, you want to know about the experts. That's all good. But I would add a couple of things. I would add things that will stop nuclear verdicts. So if I was king for the day, I would add several things. I would put a heading. What's going to get a jury angry about this case? How will you diffuse anger? And then I would say, what are you going to accept responsibility for? What number are you going to give the jury? How are you going to personalize the defendant / insured? How are you going to argue pain and suffering? There's 6 things I just came up with off the top of the head. Do everything else you're going to do. Yeah. But now you've got your defense lawyer thinking like a plaintiff's lawyer. And if he or she can execute on that, right, you're going to be far and far away, much better place than you were before.
We've looked at the causes of nuclear verdicts as well as what we can do to try to diffuse them. But one of the things that is important to consider is the impact, the shockwaves that are sent beyond just the verdict itself.
Clearly, these nuclear verdicts are having an impact on motor carrier costs. It's certainly playing out in terms of insurance costs. And we have seen in other research we've done at ATRI in our operational costs of trucking, we've seen insurance costs per mile continue to rise. So what happens, Doug, is when those insurance costs go up, carriers have to, cannibalize that money from somewhere else. And so ultimately, I may decide to invest less in safety technology because I have to pay the insurance bill. And so these nuclear verdicts are not necessarily raising the safety bar for us.
When we talk about nuclear verdicts, we often talk in numbers. The size of the verdict, the increase in insurance, the financial impact that it has. Well, there's another impact, perhaps even more important. That's the human impact. This was brought home to me within the last month or so when I was reading an article in the Arkansas Trucking Magazine. There was a story in there about Randy Clifton. Randy grew up in trucking. His grandfather had started a trucking company, and in 2001, his father did likewise. 2010, when Randy's father took ill, Randy took over the business and did well. Was successful. One day, one of Randy's trucks was pulling a load and the power unit became disabled. They needed to deliver the load, so Randy's brokerage operation brokered the load out to another company. The company came, hooked up to the trailer, went down the road. You know where this is headed. Well, that tractor of the other company lost control. A catastrophic accident ensued, and Randy's company was hit with a nuclear verdict. I'll let Randy tell the story.
That was the thing. They actually voted that they felt that he was a subcontractor or independent contractor for us and that we should be held liable. And the jury awarded him $23 million.
Yeah. Prior to the trial, Randy and his company RCX had to deal with their own increased insurance premiums because of the pending litigation, the potential for that verdict out there.
Once the attorneys got a hold of it and started looking at it, they basically set up $1 million reserve, which is basically like they were planning on spending $1 million. So it looked like I had $1 million accident before we ever got to court, which caused our insurance to double. And so that hung out there every year, right. Every different, and we changed insurances, but they see that it's still in process. It's still out there.
Even after the verdict came down, while on appeal, Randy kept at it and was able to survive.
We still had our credit line. We were still able to operate. And so, we were able to go ahead and run basically 5 years past it, but it was still a struggle with high cost.
Although the judgment was reduced on appeal, when the judgment was posted, Randy faced another problem.
They post this judgment. Well, once they posted it, they did that in January of this year. I didn't think too much about it, but we got a call from our bank, and the president called, and he was like, "We've got a problem. We see you've got a $6.5 million judgment posted against RCX." And he kind of knew about the lawsuit, and I kind of knew what was happening. But once that posted, the bank was very uncomfortable, so they froze our credit line. They basically said, "We're going to have to freeze your credit line, and we can't extend you any more credit until that judgment goes away."
And at that point, Randy had to make a decision.
Me and my wife went to dinner, and we had one of those heart-to-heart discussions, and we're done. We fought it. We're tired of it. We're just going to have to shut it down. And so could have probably tried to get some outside financing, but it was such a struggle. It was just, you just kind of give up after that point. And then the reality that this can happen again. You build your whole life, your heart and soul into something, and it wasn't even our truck, which was frustrating enough to lose this. And then to know that anything can happen down the road and you start this process all over again, it just kind of takes the wind out of your sails.
Sure. And the closing of the company? Well, that, of course, had an impact on those who worked for Randy.
We had 48 units running there at the end, and then we had 12 folks working in the office.
I asked Randy, what were his reflections, his thoughts, his takeaways? What would he like to share with others with regard to the process?
This was such a unique case where, it wasn't our truck. It wasn't our driver. We weren't the ones that actually caused it. It was just our trailer. And when you start looking at how we got drug into something and took a loss over, just like logos and just those little things like that, you really have to be careful and guard yourself. And these things, it's really happening a lot in South Texas, New Orleans, Florida. It's just really gotten bad, and something really needs to be done because it's forcing a lot of small carriers out of business.
You can measure nuclear verdicts in many ways, but how do you measure it compared to the story of Randy Clifton? Randy and the thousands like him who get up every day, run a company, accept the risk of being the owners of a business, provide jobs to employees, and support to their community. They are who we owe the aggressive defense of trucking cases, nuclear verdicts, be able to protect them from this type of thing. That is the true cost of nuclear verdicts.